Clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Thank you. We are ready to hear argument in 19-561. In re the commitment of Stoddard from Tarrant County and the Second Court of Appeals District.
May it please the court, Ms. Fletcher will present argument for petitioner. Ms. Choker will present argument for the amicus. Petitioner has reserved 5 minutes for rebuttal. Ms. Fletcher will open with the first 7 minutes and will present the rebuttal.
May it please the court. The factual sufficiency review that was conducted in this case was flawed both in application and in design. The application was flawed primarily in that they evaluated the evidence to prove an element that the statute did not require us to prove and that was never mentioned in the jury charge. The other application flaw was that the court took Mr. Stoddard's score on an actuarial instrument, decided that was his individual percentage of likelihood to reoffend, and then decided that that did not make him likely enough. They decided that by looking at a handful of other people who were civilly committed and had scored higher. In doing that, they ignored the other people who were civilly committed and scored the same as Mr. Stoddard or less. They also ignored the U.S. Supreme Court's edict that future human behavior cannot be predicted with mathematical accuracy. They actually assigned a number to likely.
Ms. Fletcher, under the factual sufficiency standard of review, what is the deference that the appellate court must give or afford the fact finder in the trial below? And did the court properly conduct that analysis?
No, that was the major flaw in the design, was that the court reviewed everything in a neutral light, whereas this court has always directed that deference be given to the jury's determinations. A neutral light does not do that. The other flaws in the design were that they actually set 4 different hurdles that had to be cleared in order for the evidence to be determined factually sufficient. The first of those, that legally sufficient evidence nonetheless represents such a risk of injustice that a new trial must be ordered, was the one originally set by the Beaumont Court back in 2010, right after the Brooks decision. A few years later, the Beaumont Court added that review be done in a neutral light. They did that without explanation, and seemingly they did it even without anybody really noticing. In the past 5 years, while the reviews have been dispersed all across the state, other appellate courts have added little bits here and there, and that is one of the things we're seeking from this court, is a single standard for review, whether that include legal and factual sufficiency, which is the state's position, or if this court wants separate reviews done, we need a single standard for that factual sufficiency review.
What if we applied the same standard of review that we have held as appropriate for clear and convincing burden of proof to beyond a reasonable doubt? Say if that's what we were to decide here, then what would be the effect in terms of this particular verdict? Couldn't they have phrased their decision within that standard, but just didn't?
You have always directed appellate courts that the standard of review has to change when the burden of proof changes.
Right.
And that's why historically the criminal standard for review has always been used in these cases, because they have the same burden of proof. That changed in 2010 when the Court of Criminal Appeals consolidated those.
But what I'm saying is that, let's say that if we use the same standard that we've used for clear and convincing with regard to the review, but being mindful that the trial court or the jury had to find, that it was more likely or beyond a reasonable doubt in this situation, and therefore the evidence had to be stronger, of course, to live up to that, to be able to pass that threshold. But if in fact that's what we did in these cases, then could their findings be pigeonholed into that standard that we articulate?
The findings in this particular case could have been, because we're asserting the findings were erroneous, but in a correctly performed review, that still leaves that little pigeonhole between that beyond a reasonable doubt the jury had to decide and that clear and convincing that the appellate court has to decide. Now, making it the clear and convincing, just leaving that little gap may be that deference to the jury's determinations that we've been talking about. The appellate court doesn't have to get to quite as high a standard as the jury did, because we are giving the jury that primary role. So that would work, I believe. The four different things that the court did in this case is part of the confusion. They recited that it had to pass the normal standard that was created by the Beaumont court in Day. They said the evidence had to be the great weight and preponderance of the evidence had to support the verdict. The verdict could not shock the conscience, and it could not clearly demonstrate bias. While all of these may be true and one and the same, to actually list out all four of those, I believe, indicates that they performed four different reviews. Now, they never mentioned any of them particularly. At the end, they just decided he was not part of a small but extremely dangerous group, which is the thing we did not have to prove and that the jury charge never mentioned. The jury was never asked if that was proven. They were never given any directions on that. And I cede the floor to Ms. Choker.
Any other questions? Thank you, Ms. Fletcher. We'll hear from the state.
Thank you.
May it please the court. The Court of Appeals erred by imposing requirements for civil commitment that exceed the constitutional minimum but are contrary to the plain language of Chapter 841. As such, this court should reverse the Court of Appeals judgment and remand for determination under the appropriate standard. First, due process requires that the state exclude the ordinary recidivist, but the Court of Appeals imposed an even higher burden, requiring the state to exclude all but the worst of the worst. The Court of Appeals interpretation requires a history of multiple sexual offenses over an extended period of time. This definition of behavioral abnormality contradicts the two-part test for a sexually violent predator, because there is no possible way to have multiple offenses over time without also satisfying subsection A1's requirement of two or more predicate offenses. That, as such, the Court of Appeals interpretation renders subsection A1 superfluous. Furthermore, nothing in Hendricks or any of the United States Supreme Court opinions requires this result. There's nothing in those opinions that suggests that the number of prior offenses must be considered as part of whether the defendant has a serious difficulty in controlling their behavior. Furthermore, another way the Court of Appeals erred is by requiring evidence of a behavioral abnormality that does not overlap with the elements of the underlying predicate offenses. Notably, the word pedophilia does not appear once in the entirety of the portion of the opinion titled Mental Illness Diagnosis and Substance Abuse Disorder. That's because the Court of Appeals completely disregarded a wholly relevant diagnosis. There is no statutory or constitutional basis for limiting the definition of behavioral abnormality this way. It's fundamentally inconsistent with the US Supreme Court's statement in Addington versus Texas that although civil commitment may involve factual inquiries, civil commitment turns on the meaning of those facts, which requires expert opinion. By way of illustration, Mr. Stoddard could have engaged in exactly the same conduct with a 16-year-old and still have committed 2 predicate offenses because sexual assault is 17 and under for minors. Similarly, if the victims had been 13 years old, it still would have qualified as aggravated assault. However, because the DSM-5's criteria for pedophilia is limited to victims that lack secondary sex characteristics, under those circumstances, Mr. Stoddard could not have been convicted or could not have been diagnosed with pedophilia. Similarly, had it not been for the 6 months worth of images of child pornography on Mr. Stoddard's computer, he would not have met the duration requirement under the DSM-5. So not only was the Court of Appeals incorrect that there was not other evidence of his behavioral abnormality, but the Court of Appeals ignored the difference that Dr. Proctor's testimony gave to the meaning of those facts.
So, excuse me, Ms. Choker, do you have any comment on the Court of Appeals considering facts that were outside of the record in the sense of, well, there are these other individuals and, you know, they're a lot worse than this. What do you have to say about that?
The Court of Appeals should not have considered such evidence as part of determining whether he has a behavioral abnormality because, again, the definition of behavioral abnormality does not refer to any sort of reference as to, it's not a spectrum of difficulty controlling behavior. It's a yes or no question under the definition. Other states took different approaches. For example, under the New York civil commitment scheme, they actually will determine that someone has a behavioral abnormality and therefore is a sexually violent predator, but limit required inpatient treatment to essentially the worst of the worst. And they do assign different levels of difficulty and dangerousness. And everyone else would be able to obtain outpatient treatment. That's not the course that the Texas legislature chose. Returning to the question of how many offenses and whether it was appropriate to disregard the pedophilia diagnosis, the Court of Appeals approach ignores the statements in Hendricks and Crane that civil commitment, that the procedures for civil commitment have to be sufficient in light of the nature and severity of the diagnosis. And so for something like antisocial personality disorder, where it's more difficult to determine which ones actually lack control, it makes more sense to rely on an actuarial instrument such as the static 99. For example, going back to the illustration of this engaging in the same conduct with a 16-year-old, someone may engage in sex with a 16-year-old because they can't control themselves, or they may be able to control themselves and simply choose not to as long as they think they'll get away with it. It just doesn't carry the same implications as a pedophilia diagnosis does. Sex with a prepubescent child, however, is nearly always going to be, as the court said in Addington v. Texas, quote, something more serious than is demonstrated by idiosyncratic behavior. It simply doesn't fall into that category of behavior that at one time or another, every person exhibits some abnormal behavior.
Ms. Choker, in doing a legal review of a factual determination made by the jury, courts sometimes do look at other cases for benchmarking, like in connection with determining whether punishment is cruel and unusual, and looking at ranges of damages for punitive damages or mental anguish damages. Are you saying that the Court of Appeals should not have looked at other cases and gone through this exercise? Or are you saying they just, whether or not they should have done it, if they did it, they didn't do it correctly?
A little bit of both, Your Honor. Benchmarking may be appropriate, but it can't be the dispositive factor. And furthermore, unlike some of the doctrines that you were pointing to, the question of behavioral abnormality is one that requires expert testimony. And so it doesn't make sense that the court would be any better positioned than Dr. Proctor, with all of his experience, looking at a much wider set of cases to determine whether he has a behavioral abnormality. I see my time has expired. We ask that the court reverse the Court of Appeals judgment. Thank you.
Any other questions? Thank you, Ms. Joker. We'll hear from the respondent.
May it please the court, Ms. Dunsmore will present argument for respondent.
Mr. Chief Justice, may it please the court. Dr. Proctor, according to him, doing something with a person who can't or didn't give their consent is sexual deviancy. And not living a law-abiding life constitutes antisocial traits. He described these two things as the most important factors, risk factors, for determining whether or not someone has a behavioral abnormality. What he did not mention is that every single person convicted of a sex offense has done something to someone against their will, and every single person convicted of a sex offense has broken the law. So there is no limitation whatsoever on the amount of risk that must be shown in order to decide that someone has a behavioral abnormality. The way it stands now, it could be applied to every single sex offender, which hardly takes into consideration the legislature and the constitutional restrictions requiring it to be applied to a small group. Now, the state's experts often like to describe the combination of antisociality and sexual deviancy as making civil commitment especially dangerous. But since all the sex offenders have displayed these characteristics, I don't know where the especially part comes in. They all have a risk of recidivism. Merely by the fact of having been convicted before, there will be some percentage of recidivism risk that takes them out of the realm of being merely possible, which is the standard that they use for above merely possible, which is the standard that they use for being likely to offend. And so a law that could, a legal sufficiency standard that could apply to literally anyone, mandates that there needs to be a factual sufficiency mechanism so that when it is being applied inappropriately, there is some option for a court to step in. Regarding the neutral light, there are cases using the same or similar language as the Stoddard court used regarding everything from oil field contracts disputes to family law to juvenile delinquency. In fact, there are dozens and dozens of them from every single court of appeals. A lot of them cite back to this court's Kane versus Bain, which was a 1986 case about the sale of a house with foundation issues, which, while it doesn't use the word neutral, does say that the Court of Appeals must consider and weigh all of the evidence, which certainly implicates the notion of neutrality.
So, Ms. Dunsmore, excuse me. So are you arguing for a standard that would incorporate neutrality, or are you arguing that it be something different, but that nevertheless your client would still be able to prevail?
I'm arguing that there should be a standard that incorporates not viewing all of the evidence in the light to support the verdict, which is what the state is asking for. Essentially, what caused me to bring up these issues in the first place was a lot of the appellate courts were saying, well, there's legal sufficiency, so there must necessarily be factual sufficiency, and not doing any analysis beyond that. So the turning it into the criminal standard, they were kind of doing it anyway. The Stoddard court, I asked them actually to go with what you had brought up earlier, the clear and convincing, because the Constitution requires at least clear and convincing. And it seems that applying a preponderance standard where you have to show injustice in order to set the verdict aside, seems that to me that it's judging a reasonable doubt respondent by a preponderance standard, so that there should be something more there. The court did not go where I asked them to go. They applied the standard that everybody else has been using. But when actually analyzing all the factors, they decided to go ahead and that he did not fit the definition.
So, Ms. Dunsmore, you're arguing that your client would nevertheless prevail under the clear and convincing type standard that Justice Lehrman mentioned earlier as well?
Yes. Yeah, I think it would be even more obvious that he would prevail.
And can you go into that a little bit?
Sure. He essentially had, the statute's directed at repeat sexually violent offenders. The courts have decided, and your court has refused to review the idea that requires two separate incidents. So it can be one incident of sexual molestation with two different charges attached to it. So already the repeat element is really is not present in the same way. And the statute's directed it according to the 841.001, they intended it to be applied to these people that have a compulsion and are going to sexually offend no matter what, unless they are locked up. They did not intend for every sex offender to have to prove that they are eligible to babysit children before they can be released. And that standard, as ridiculous as that sounds, that has actually been advocated before. Would you want this man to babysit your children? There needs to be some kind of mechanism to say that's not appropriate. And if you do what the state is asking you to do, which is basically ignore the legislature's intent as expressed in 841.001, then that there's nothing at all to put the brakes on that. As far as I just wanted to, the mentioning facts outside the record, I guess I was going to say what you said. You kind of handled that for me. The issue with the 841.001 is, for one thing, statutory construction says that you consider all parts of a statute and you assume that the legislature put everything there for a reason. It's not legislative history that, gee, the statute doesn't say anything, we need to go look up what happened at the hearings. I mean, they deliberately put it in the statute as a direction of public policy and the intent of the statute, and to be used as a guide to what sort of people they mean when they say likely to reoffend, because every offender is likely to reoffend. So it can't be a small group if it applies to everyone. So in order to give some guidance to what likely means, without strictly defining it in a way that would constrain, there's so many variables. I don't think you could define it in a way that would actually narrow things. You never know what sort of, you'd have to define it to, if they make a confession or this or that. The circumstances of each case are different. So the likely standard is something that should be determined on a case-by-case basis, but within the guidelines of having it, the goal is that small group. And the state has been pretty adamant about not wanting the jury to even hear that maybe they should be aiming for somebody who's such a dangerous person that they're part of a small group and not just the ordinary sex offender. So they've been objecting to our side even mentioning that 841.001 exists, and trying to characterize it as something, an extra element that must be proved. But it's not, it doesn't need to be proved to the jury. But I think that the evidence of it still needs to be there. And in the same way that constitutional constraints are like with exemplary damages. The due process aspect that the Supreme Court has said, when it's an unpopular defendant, you can't just let the jury throw the book at them because they don't like them. So the appellate courts need to be able to step in and constrain those awards. But the same sort of logic applies. The jury doesn't necessarily have to be told, they could be, that would be one way to do it. They don't necessarily have to be told it's part of a small group, but the appellate courts shouldn't also then ignore that the legislature wants the group to be small.
Counsel, do you know how many SVPs there are currently committed in Texas?
I think it's about 500. I'm not sure of the exact number. They're all located at Littlefield, and it has been going up. When I started doing this several years ago, it was 200 or so, and now it's so the rate of sending them off has increased. I know that the very first person that was ever released was released in 2016, and there have been only I'd say less than a dozen since then. They've had a couple recently, but I think it's still under a dozen. So to all intents and purposes, this is a life sentence. And just given even the enormous number of resources it takes to keep someone for life and treat them, and have the psychologists and all the things that the Supreme Court has indicated show that it's a treatment and not a punishment. The idea that we would take up spots that should be reserved for truly dangerous people by putting people in who are highly unlikely to reoffend. I don't think it's a good idea. And one of the things that the experts do, they don't give any consideration at all to the effect of a long sentence on someone. Mr. Stoddard served 20 years, and the fact that he does not want to go back tends to focus the mind somewhat. They don't give any consideration at all to the fact that it's not even weighted as one of the factors that, the length of incarceration would perhaps reflect on somebody, what somebody's likely to do. And so it essentially disregards our whole criminal justice system, which one of the goals is deterrence, and in addition to punishment.
Along those, sorry, go ahead,
Justice Blacklock.
Thank you. Along those same lines, do you have any idea how many repeat sexually violent offenders there are, who would have been eligible for this determination? So if 500 is the numerator, what's the denominator? Do we have any idea of the percentage of people who are eligible as repeat sexually violent offender end up being civilly committed?
I do not, but I believe that the Fort Worth Court of Appeals mentioned some of the figures in their opinion. They sort of did a background about, I do know, responding to one of the things the state said, she seemed to be implying that the mere act of being a pedophile alone was enough reason to determine someone is so dangerous that they need to be locked up. And I do know that 1% to 2% of the population has sexual interest in children, inappropriate sexual interest in children. Doesn't mean they act on it, but that's a lot of people. Right? We're talking 3 million plus people if you look at the population of the United States.
Just to be a little more specific about Justice Blacklock's question, I suppose there are some people who meet the, who have had more than one offense that would make them eligible for the state to seek to have them civilly committed. And so I guess one part of his question would be, how many of those people are there who would be eligible, but the state doesn't seek to have them committed? And then the other part would be, how do you have a sense anecdotally of how many people the state does seek to have committed, but they're unsuccessful. The jury doesn't find.
Oh,
they,
okay. That one I can answer. There have been 6 out of 500 or so cases. There have been 6 times that the jury has returned a verdict finding that someone did not have the sexually violent offense. It's unfortunate, but most people, they kind of shut off when they hear sex, especially with pedophiles. When they hear that, they sort of, in fact, voir dire often takes a really long time because it's difficult to come up with enough people who say, well, once I've heard they've committed 2 of these offenses, I can still keep an open mind about whether or not they have a behavioral abnormality. They often have a really difficult time coming up with people who can hold with that. And in terms of the number of people they could apply it to, that's one of the things. Oh, I'm sorry.
The statement you said that 1 to 2% of the population has desires for pedophilia. I mean, that strikes me as a sort of a dubious proposition, but let's assume that that's true. That would be that Texas has roughly 30 million people. That's 300,000 Texans with these tendencies, and only 500 of them are committed. That's a pretty small percentage. I mean, it sounds like 500 out of 300,000 might be doing a pretty good job of identifying only the small but extremely dangerous group.
Well, when they said small but extremely dangerous group, they weren't looking at the whole population. There are people that have these instincts and just they never do anything about it. And then there are people who, and actually, I should point out, Mr. Stoddard is one. He wasn't. Dr. Proctor didn't diagnose him as a straight pedophile. He actually has relationships with adult women also. So that is not his only sexual interest, as opposed to some people that the only sexual interest they have is in children. But one of the issues we have is that what you asked earlier about the state, how many people are eligible for this and don't get brought up for commitment. And to be quite frank with you, we have no idea. The doctors say that they turn some people down and don't find that they have a behavioral abnormality, but they never hand over notes when requested to find out who are they considering okay and who are they not considering okay. So it very much is an area where a little science could be applied, and we could see what the criteria there. It would be nice to know what criteria they're not considering, who they're not considering important. We really
excuse me, Ms. Dunsmore, I'm sorry, but so let's say for we're going to have to enunciate what we're going to do here, or I assume we will, with a factual sufficiency review in this context of beyond a reasonable doubt. And let's say if if our standard is something to the effect of with disputed evidence, a finding that the reasonable juror could not have credited this in favor of commitment. So if that's what we do, in light of what you're saying now, which is that there is this preconceived feeling among potential jurors that anybody who is ever engaged in this type of behavior fits the criteria for commitment, how do we mesh those two? What is your suggestion?
Well, since it is beyond a reasonable doubt standard, what I'd really like to see is the elevated, basically take the clear and convincing wording and insert, insert reasonable. Could they have, looking at it objectively, could they have possibly found this beyond a reasonable doubt? But in terms of,
so you're saying that would be sufficient? Do you think that if we did incorporate that analysis, that it was a much higher burden for the jury to find, that it would be easier for us to find that no reasonable person could have come to that conclusion? You think?
Well, I think part of the problem is that these, there are no sort of elements that, like with the criminal case, you have the, was there intent, was there opportunity, and things that you can sort of check off to see, is this part fulfilled? Is that part fulfilled? And when it comes to credibility determinations, in a criminal case, you're looking at a situation where, if witness A says, oh, I saw him rob a bank, and witness B, who's his girlfriend, says, no, he was home with me, and the jury chooses to believe witness A, that's a straight credibility determination. Whereas you don't really, these experts, they say a lot. Some of what they say can be shown and seen from the evidence, and some of it, we kind of have to take their word for it, that when they say the literature says or the research says, but there's no weighting usually on any kind of actual numbers. And when they have the standard of beyond a mere possibility equals likely, that's basically anything above. I mean, mere possibility is that's which it's possible because you can't prove it impossible. And that's what makes it merely possible. And if you have a standard that anything above that is actually the same as probable, there should be a lot of daylight between above merely possible and actually probable. And there isn't. There's no guidance given to the jury. Recently, the state said 1% would be enough to a jury. The Fort Worth court also, they noted it in a footnote. It was a case that they didn't decide that on, but they did say, we're not sure we agree with that. But it's fairly common for the percentage of likelihood to reoffend to be very low, like below 5%. And the experts try and avoid talking about that to the jury. So all they hear is, well, the person's likely to reoffend. And likely essentially means whatever you want it to mean. So I mean, honestly, given the way the deck is sort of stacked, I'm surprised we get jury verdicts in our favor ever. So
Any
now
other
my
questions?
time is.
Thank you, Ms. Dunsmore. Ms. Fletcher, I believe you had 5 minutes.
Thank you, Chief Justice. The discussion about how many people could qualify for this and how many actually do ignores all the screening steps that are in the statute. In 2018, the Texas Civil Commitment Office made its report to the legislature, and in it, it showed that 95% of repeat sexually violent offenders are screened out through the administrative processes and never actually hit a prosecutor's desk for consideration of civil commitment. So 95% never hit the courts. On average, we lose about a case a year. Our experts, there is an expert that evaluates the person before the referral is ever made to the prosecutor. Dr. Proctor never works in that position. He only works after the case has hit the prosecutor's desks. And he testified that 25 to 30% of the time, he still reports no behavioral abnormality. So these experts, whether it is the psychologist or whether it's the multidisciplinary team or TDC itself, they are screening out these people for whom civil commitment is not proper.
Ms. Fletcher, Ms. Dunsmore mentioned that the way that Dr. Proctor structured his testimony about behavioral abnormality effectively meant that he would find a behavioral abnormality anytime somebody has committed a sexually violent offense and repeats it more than once. And I think her implication was basically that makes the behavioral abnormality element of the statute redundant, because if you meet the first two elements, you're always going to have a behavioral abnormality. Do you agree with that characterization of Dr. Proctor's testimony? And if so, is that a problem?
Absolutely, I do not agree. His testimony was that 25 to 30% of the time, he finds no behavioral abnormality. And so clearly there is something more than that repeat offender status that it takes to qualify.
And is it clear from his testimony what that is?
He talks about the interest in children. One of the big factors that we see from our experts is the person's recognition of what they have done, how it was wrong, how to prevent that from happening in the future. That tends to be the difference maker. We had one case where mid-trial, the expert listened to the person testify and then informed our trial attorney, I've changed my mind, he's got it now. So a lot of it is just that understanding and that intent. Mr. Stoddard does not have that. By statute, all respondents in these cases are entitled to their own expert evaluation, and that is funded by the state. If that expert is not presented, we must presume that testimony would not have been beneficial to the respondent. The factual sufficiency, even if it is kept, it is not the only thing protecting these people. The statute itself protects them with the various screening labels, but it also protects them with that highest burden of proof. That is a huge protection. That's what we use to protect people whose lives are being taken for capital murder. So that is a huge amount of protection. It's not nothing. Ms. Dunsmore also talks about he's not really a repeat offender because he got all of his convictions at one time and went to prison. The legislature knows how to require repeat trips to prison as it does in the criminal code, and that's not what it did in this case. He offended, by his own admission, more times than he was caught. And that is often true, particularly of pedophiles. 841001 does not need to be separately considered. The definitions and the requirements of the statute encompass all the constitutional requirements. And if those definitions, the two things they tell us, the behavioral abnormality, the repeat sexually violent offender, are proven, then that verdict should stand if a rational juror could find that.
Any other questions? Thank you, Ms. Fletcher. The case is
Thank you all
submitted.
for your time.
The court will take we'll take a brief recess.